Good afternoon, everyone. My name is Kathy Purdy. I'm the Marketing Supervisor at Schoeneck King. I'd like to welcome you to today's webinar presentation for Q&As about Department of Health and the New York State Education Department reopening guidance. Two quick housekeeping items before we get started. Please submit any questions that you have through the Q&A box located at the bottom of your screen, and our presenters will do the best they can to get to those at the end of today's presentation. Also, once the webinar has ended, if you would take a moment to complete the brief survey, we would appreciate that. So to get things started today, I'm going to turn today's presentation over to Bethany Centrone.
Good afternoon, everyone. My name is Bethany Centrone. I'm the co-chair of Bond School Law Practice Group. I'm here today with my colleagues Kirsten Barclay, Candace Gomez, and Kate Reed, also from our school law group. We appreciate you joining us today for this much needed conversation. I know it's hard to believe that it's only been 3 months since we first presented on planning for school reopening plans in mid-April, and how much has changed since then. Today we are scheduled for an hour and 15 minutes and certainly aren't going to be able to parse through all of the details of the DOH and New York State guidance, which combined with all of the guidance that's referenced is hundreds and hundreds of pages. But our goal today is to provide some high-level analysis and overview in areas where the guidance is ambiguous and provides substantial choices for school districts and the schools, and then take time to, a significant amount of time to answer your questions so that the issues that are most important to you can be answered as opposed to what we think that you want to know. We will have some questions at the end of our main points that we've prepared to get things started, but really hope that you take advantage of that Q&A box at the bottom so that we can answer your questions specifically. And with that in mind, we want to start our disclaimers for the presentation today. Our answers today are going to be based upon what's currently available in information and guidance, and that is an important caveat in the sense that we already know that some FAQ information was released over the weekend by the State Education Department, which is not yet published, but was released to superintendents. So we're trying to keep as up to date as possible as things are released, but things may change on a daily basis or hourly basis as things have happened since COVID began and school closures began. So you really want to make sure that before implementing something, if you have questions, that you check with your counsel, either if that's us or others, so that you're sure that your plans are compliant with the most current information and guidance that's out there. Next slide. So with that in mind, just to identify what the relevant documents are now. So there's the New York State Department of Health interim guidance for pre-K through grade 12. That was released last Monday or Tuesday. And within that document, there are a number of references to interim guidance that the Department of Health had issued previously for reopening of other private businesses, so office-based work, public transportation activities, guidance for sports and recreation, and guidance for food service businesses. And probably you are familiar with those because in the absence of, in the vacuum that we've had as school districts for specific guidance for us over the last few months, many of us have been looking at those for at least some kind of analogy that we could use to try to create plans because we knew that they were upcoming, but didn't know what they were going to be required because we didn't have our specific guidance yet. But I want to point that out to make sure that we're looking at those when we're creating our plans, and we're looking at those prior guidances which are specifically referenced in the DOH. And then next slide. The SED guidance also incorporates several other guidance documents. I will note that all prior Department of Education and NYSED COVID-19 special education guidance are specifically referenced in the current SED guidance as still being current. and then many of the CDC requirements as references as to how we're supposed to either put into place safety measures or identify symptoms. And these are listed just again so that you have references for those in case you haven't looked at them. And the websites for these are at the end of this presentation. And if you are, are also embedded in the electronic documents and guidance that's been provided by the DOH and NYSED. Go ahead, next slide. So what do we do? Because all these things are usually as clear as mud with regards to each other. So what do we do if there's conflicts within all of these documents? The first and foremost, as indicated in both the DOH and NYSED's guidance, if there is a health and safety concern guideline, the DOH guidance applies. So if we're worried about what social distancing means, if we're worried about what types of disinfecting we're supposed to be doing, if we're looking at what PPE is required, those are health and safety mechanism requirements, and we would look to the DOH to get our minimum standards of what applies. If we're looking at anything else in relationship to instruction or what constitutes units of study and those types of things, we would look to the New York State Education Department guidance, and with the knowledge that the newest guidance always applies for the New York State Education Department. So when they come out when that frequently asked question document finally comes out and is published, we will be looking at that to see what the State Education Department's current thoughts are about what we're supposed to be doing. Next slide. So again, we're going to take a look at a high-level look at some of the issues I think that are most pressing for us and are creating the most consternation in relationship to how are we going to open. And one of those, the biggest I think of that is the social distancing requirement. Under the DOH guidance, again, this would be a health and safety issue. It says that social distancing is either 6 feet in all directions or appropriate physical barriers, and also defines that social distancing is 12 feet for certain activities. So physical education, where students might be breathing heavy because of exertion, chorus, singing and chorus, or band where there's wind instruments involved, are examples of activities that would require 12 feet for social distancing as opposed to the 6 feet standard that we've all been hearing since March. However, the DOH guidance also says that you have to social distance unless the safety or the core activity, which includes instruction, moving equipment, using the elevator, traveling in common areas, requires a shorter distance or the individuals are of the same household. So what has been issued in the frequently asked question documents that hasn't been published yet over the weekend is that the State Education Department FAQ has relaxed what seem to be very, very strict requirements that the SED put out beyond what the Department of Health would have required. And SED is taking the position so far that we have to ensure that students and staff are protected by at least one of the following, which is social distancing of 6 feet or barriers or face masks and covering. And this was a significant conversation in a call with the school bar that we had on last Friday about whether schools could have full classrooms if students were wearing masks. And we think, based upon this FAQ, that would be allowable in the sense that you could have students closer than 6 feet. One of the things that we want to point out, though, is that the guidelines that are out there by the state and the State Education Department and the Department of Health still recommend and say should quite frequently in relationship to the social distancing requirements, and provide that you can substitute masks when it's not possible to social distance. And so what we would warn folks about in that sense, in that in that context, is that even though it's may not be specifically required by the guidance, and we have some leeway in relationship to the use of masks or barriers instead of social distancing, we should really try to do the best that we can to create an environment where there's distance with the students in the classroom, and determine whether it is or isn't possible to socially distance before jumping headlong into having our standard classrooms with students just having masks on, because we still will be subject to negligence standards out there if students become ill, and could have liability in relationship to illness of students and their families if they take it home with them, should we not be committing to best practices. So again, it does not appear that it would be mandated by the guidance, but we should try to do the best that we can, I think, to ensure that we are making, we have a clear determination that it's not possible to socially distance when it's not possible to socially distance, and we have documentation of that, and we're doing a true evaluation of those of that when we're looking at what our plans could provide. Next slide. The next issue we think that likely is going to create some concern and bottleneck for clients is the screening requirements. Both the DOH and the New York State Education Department guidelines, again, it is a safety issue, so DOH applies, require that anyone entering a school building have a daily temperature check, and that is staff and students. The guidelines all say that there's a preference to have these checks done at home. However, it is the school's responsibility to ensure that those checks are completed. And so we can say the parents have to do them at home, but we need some kind of mechanism for getting that data back to us before or early on in the day when students are coming to school. And we cannot save any specific data, so we can't save information that a student's temperature or an employee's temperature, for example, is 98.6. All we can save is the data in relationship to whether the student was cleared or the person was cleared to come in the building or was not cleared to come in the building. And for those of us who've been using sort of paper and pencil sign-in sheets, I think, again, that is something that we want to make sure that if we are having people sign in and check a box, they're just checking yes or no. None of the screening questions apply to me, or they do apply to me, rather than having them answer specific questions about those screenings. So we shouldn't have people walking in the door with a sign-in sheet that says, yes, I have a fever today, or yes, I've been exposed to somebody today. It really should just be, you read the requirements or the questions, and you're saying yes, you can answer no to all. You can say you're answering no to all of those questions, or you're not answering no to all of those questions. So and I think that we need to make sure that that's in place. Health screenings, and those are the questions. Do you have any COVID symptoms today or within the last 14 days? Do you have any? Have you been in contact with close contact with anybody who has had tested positive for COVID? Have you tested positive for COVID in the last 14 days? And have you traveled to any of the restricted areas? Employees continue to have to respond to those questions every day. And again, it's supposed to be before they come to work. As practicable, the guidance says for visitors, contractors, and vendors, I would argue that we really want to do that for anybody that's walking in the building on a daily basis. And then the guidance says periodically students are going to have to answer those questions, or their parents if the students are too young to answer those questions. So you would want to establish your protocols for how frequently that you're going to answer those questions and what you're going to do if you don't get their responses back. And the guidance also recommends, and we would recommend that this be followed, that there's somebody that's designated to review whether or not those screenings come in on a daily basis for the temperature checks and the screenings, health screenings from employees to make sure that they've all been, anybody who's in the building has been screened appropriately. Next. So what happens if we have a positive? Again, another issue that I think is going to be on everybody's mind. So we have somebody is positive that we learn, or they just come to school or come to work and they indicate that they have COVID symptoms. There are inconsistencies in the state education department guidance and both the DOH guidance, in the sense that they both say that individuals who screen positive must be immediately sent home, but they also say that they should be sent to the school nurse in the health office to be evaluated by the school nurse and sent home for symptoms that are not explained by a chronic health condition. I think that does, it's good in the sense that every person that says that they have a headache may not be required to go home, but we are also in a situation where we would be needing to make a determination independently, and certainly our school nurses may have some concerns about having to make that determination independently. So in an area where you will be having some discretion on how you treat individuals who screen, answer questions positively, certainly if they have a fever, they have to be sent home. But how you want to determine how you're going to address that, whether you're just going to send everybody home right away, or you're going to have a screening, a determination by that nurse, and it has to be on our end, in your school nurse, as to whether or not they need to go home on a specific basis. So, and we also have concerns about, there are concerns about abuse in these situations where people are going to potentially say that they have symptoms where they might not have symptoms, and questions about use of leave and paid time off if they are screening themselves out. And those are things that, again, that you're going to have to address before school opens, or may have already been addressing with your 12-month employees, because we should have already been asking these questions of our employees. What do we do for somebody who's screened positive or has tested positive? The state education guidelines are strongly recommending that schools do not require testing of individuals who either screen on their health form that they have symptoms, or who test, or who say that they might be sick or identified as being sick. What that does, unfortunately, is that we are, if we do not test them, then we can't have people come back to work right away. And if they're not tested, they cannot return at least 10 days from the start of their symptoms, or 3 days after their last fever or symptoms have improved. So I think that we're going to be in a situation where we have to have something in place for our students who are going to come in and say that they have a headache, they have a stomach ache, they have a sniffle, they have a cough that day. All of these things that are COVID symptoms are symptoms of a lot of general illnesses that kids get all of the time and people get all of the time. And what are we going to do on a go-forward basis to deal with students who are sent home, or who may have had contact with somebody with COVID, who are healthy and can participate in school, and how our plans are going to address those particular students if we have in-person instruction, typically for all of our students. Next slide. A third area that has come up in questions so far for us, and was again another area of conversation between school attorneys, is the vulnerable populations. Vulnerable populations, as you likely know, are individuals with underlying conditions, and those are listed in one of those CDC links that were referenced previously, but they include high blood pressure, they include obesity, condition, medical conditions such as cancer, asthma. The state education department also lists pregnant individuals, people who are 65 or older, and also students who have family members who are at high risk. The DOH guidance goes on to say that it might include that there's also a consideration for individuals who may not feel comfortable returning to an in-person education environment, which is probably where we're most concerned in relationship to being able to staff, in relationship to families who may be concerned about sending healthy children to school, even though they don't, without any underlying conditions or reasoning. We believe that if an individual, a student or an employee has their own underlying medical condition, we certainly have an obligation to accommodate those with medical conditions for employees under the ADA or the human rights law, for students under Section 504 of the Rehabilitation Act. So we will want to address those students and those employees individually in relationship to what they're requesting. Under both of those scenarios, either students or employees, they're not entitled to the accommodation that they're asking for. They're entitled to a reasonable accommodation. And so if there are accommodations that provide a higher level of protection in the school environment that don't necessarily require the student to stay home or the employee to stay home, those can be considered. But we shouldn't just dismiss those accommodation requests out of hand because it's not possible. We need to evaluate those individually. We believe that where an employee or a student, they themselves do not have their own underlying medical condition, that there isn't a statutory obligation to provide specific accommodations or to provide reasonable accommodation. So those people who may just be uncomfortable not coming into school, there's no statutory or regulatory or legal obligation for us to accommodate them. We may want to consider what we might do for people who do have concerns. We also can expect that there's going to be potentially an uptick in mental health related issues or requests for home instruction or for working from home that are also going to need to be evaluated. In relationship to the issue of having a family member or a household member that may have an underlying condition that puts them at risk, there is not a consensus, I don't think, that of our obligation to accommodate those. It is in the New York State Education Department guidelines that they would be considered vulnerable populations. But I think that if you're considering not providing accommodations for students who have family members who may be vulnerable at home, that's something that you should talk to closely with your school attorneys or with us, if we're your school attorneys, to talk about what risks are associated with that and whether they're and what the benefits are of potentially providing accommodations if necessary. Next. The other part, I think another part of the guidelines that we've identified as being a potential for lots of, there certainly is a lot of discretion, but potential issues going forward for our school districts is the prioritization language, and certainly that's very much emphasized in the Department of Health guidelines for who should be returned to in-person instruction more quickly, and is suggested but not as strong, I don't think, in the New York State Education Department guidelines. And these, of course, are students who are seen to be benefiting less from or not getting significant benefit from the remote instruction that has occurred over the last 4 months of the 1920 school year. or younger children in the early grades, students with disabilities, and English language learners. Certainly, students in poverty that don't have the resources, and not listed here, but that may not have the resources to be able to access online instruction, of course. But what we wanted to point out in this overview, and certainly our Q&A will flesh out, I'm sure, a lot of the specific issues that are on your minds with this, is that students with disabilities and English language learners are their own, there are protected categories. We have statutory obligations. Of course, you know that for students with disabilities to ensure FAPE and to ensure that they get the services that they're entitled to receive under their IEPs. And we've been dealing with that from an ESY perspective, but right now we have guidance that says you should be prioritizing these sections of their student population. You need to figure out how to get them back into school so that they can have FAPE. So our arguments on the other side of that in relationship to providing remote instruction, potentially if we are providing remote instruction to these categories of students, we want to make sure that we are able to either address the fact that they are receiving FAPE. Some students with disabilities are excelling with remote instruction because of their specific needs and how they access learning. We can show that they're either getting what they need to get out of the distance learning, or that there's some specific reason. They may be medically fragile or have other underlying disabilities that cause them not to be able to comply with the safety requirements. So you may have students that are emotionally disturbed in a self-contained classroom who aren't going to wear a mask and aren't going to stay 6 feet away from anybody, right? So, but those analyses need to be done so that if you are faced with a challenge later on, that it's not going to necessarily prevent you from having to provide some kind of compensatory education or something for those students if they're not getting the services that they need, but making sure that you have a case-by-case and student-specific analysis of what is available at a particular time could save you from a civil rights case later on for knowingly and intentionally violating the civil rights of students who have disabilities. So we want to make sure that we are being very, very thoughtful about providing case-by-case determinations for our students with disabilities and our English language learners with regards to services, and not just saying as a blanket, we can't do this safely, and so therefore we're not going to bring these populations of students back. And with that, we're going to start our Q&A. I know that there's a number of questions that have been submitted. So
good afternoon, everyone. I'm going to try to moderate. We're getting great questions in the Q&A. So I think before we go forward with the questions that we've already heard from our clients, we'll stop and address some of the questions that are directly tied to the information that Bethany just covered. And the first question, Bethany, is what if somebody checks yes for the symptoms of COVID, but on their screening, but on their follow-up, they indicate that they think or they know that they're just having allergies, for example. Is the school district required to have that person follow up with a doctor to get clearance? And the second part of that is there a difference in your answer depending on whether it is an employee versus a student?
That is one of the difficult questions in relationship to the guidance, because there's sort of two different answers based upon where you read in the guidance. But the state education department guidance does allow for evaluation and determination by the school nurse. If somebody screens positive or checks a box that says that they have a symptom, or they have a symptom and somebody, sends them down to the nurse. And I think that, and the guidance also reflects on chronic health conditions. So if I have allergies, that would be a chronic health condition, presumably. And we have the ability pursuant to that state education department guidance to say this is a chronic condition, and and so we don't think that they need to have a follow-up. The guidance specifically says that if there is no school nurse or there is no chronic condition, we would have to exclude the employee or the student from the building and have them follow up with their healthcare provider. It is unclear. Well, I guess it's not unclear. It's actually fairly clear from the guidance that if someone has those symptoms and they're not tested for COVID, then they should be excluded from the building for the period of time that is required under the guidance, which is the 10 days or the 3 days based upon what their symptoms are doing. It's possible that there could be further guidance that if a healthcare provider clears them and says that they don't have COVID symptoms, even without testing, that there might be some ability to get some leeway there. But right now, the way that the guidance reads, unless we have a negative test, we would have to presume that they have COVID symptoms and keep them out for that period of time. And I think the same applies to students. The guidance is other than how frequently that we have to provide the screening questions, the guidance in relationship to positive answers is the same. Does anybody else, Candace or Kate, have any additional thoughts? I don't want to.
No, I think you summed it up. Thank you, Bethany.
Mm-hmm.
So another question is to clarify the term periodic screenings. Do we have a recommendation for how often we should be performing periodic screenings for students? And Candace, I don't know if you want to take this question.
All right, so we know that for employees, it should be done on a daily basis. The state education department guidance references periodic screenings for students. So we know that temperatures definitely need to be checked every day for students, and that needs to be done preferably prior to their arrival at school by their parents, or at the very least, once they arrive at the school building before they are released to a classroom. The periodic screenings with that list of questions that Bethany mentioned about whether they've had contact with someone who has been diagnosed with COVID, those more in-depth questions. We don't know what they mean by periodic as far as whether that is once a week or once a month. I would venture to say that as a best practice, it should probably be completed on at least a weekly basis. I think going a month between these periodic screenings would probably be viewed as not being very effective. So, certainly I'm open to what the other panelists have to say, but I would think at least a weekly screening for students would be a smart idea.
And I would agree with that. I think at least, and I mean, I think that it would be nicer to have it more frequently, given that guidelines say that symptoms and can develop within a few days, or testing positive usually takes a couple of days after exposure. However, I think trying to screen all of your students every day, more than once a week is probably going to be more of a burden than most of us can handle. And once a week seems to be a fairly reasonable period of time. I suppose, you ask if you've been in contact with anybody for the last 14 days in the screening questions. That could be another marker, but we just need to realize that the farther we go out in relationship to those periodic screenings, the more likely it is that somebody's going to get through and are going to potentially report to work or come to school with that could be COVID positive. Also, we're supposed to be training our parents and our families and our staff not to come to work or school if they have symptoms. So hopefully they are screening themselves out, but I think it's going to be a balance between safety and wanting to make and sort of practicality.
Thank you both. A question that I'm seeing throughout the questions, so several people are asking whether, what to do when parents cannot come or do not come to school to pick up a sick child. Similarly, can you require parents to commit in advance to coming to school within a certain time period? And or can you require parents to complete hold harmless agreements and liability waivers related to exposure?
I can get started on that one. So there's a lot to unpack in that series of questions, but the question regarding what to do if a parent will not come and pick up a child, the guidance is clear that students who are symptomatic or screening positive must be segregated from other students and kept in a separate location. That would have to be maintained even if a family member is refusing to come and pick up a child. At a certain point, and I know many of you probably have had similar discussions with us regarding the issue that arises when a student who is unvaccinated, for instance, is not being picked up by a parent. We were all concerned about that last year. At a certain point, if a family member refuses to come and pick up a child under those circumstances, that may trigger your obligations for a parental neglect report to the CPS hotline and potentially enlisting the assistance of school medical personnel and as well as emergency personnel as necessary. The question regarding a liability waiver, hold harmless, there's some overreaching considerations, I guess, in answering that question. The first is to consider that under prevailing New York State law, a parent cannot actually sign a liability waiver with respect to the claims of a minor for personal injury unless that waiver is approved by a court of competent jurisdiction in New York State. So waivers are of somewhat limited utility when you're talking about children, which is what we're all talking about today is children. Those claims, you may be able to secure a waiver as to the claims of a parent. Whether that waiver is going to be binding with respect to the child is very uncertain. There's also the fact that children, in the public school context at least, have a right to a free public education, the right to attend school. So there has been some authority that conditioning the attendance in school, participation in school on the execution of waivers by parents is largely disfavored. So we do not recommend that as an approach for dealing with the liabilities at issue here and the personal liability and personal injury considerations. Better course of action for that is to consider ensuring that your insurance is as trued up as possible so that if you are faced with a claim for personal injury, you do not have a deficit in insurance coverage that would come in to pick up those types of claims. I don't know if Bethany or Candace has anything else to add.
I think that's a pretty good, and getting the waiver from the parent of the student who isn't getting picked up isn't protecting us really against all of the claims from all of the other students who might have been exposed. Right, so I think that's, to the extent that even if we were to get a waiver in the case of parents who aren't picking up their students or claiming sick students, that issue, I think it even further limits the amount of protection that would give.
So the next question has to do with the guidance requirements relating to a reopening coordinator. The question is whether the guidance requires that each school building have its own coordinator or whether the district coordinator is sufficient.
Right, so I'll start off with that one. So the guidance references a coordinator and it says district/school. So it seems that the coordinator can either be a district-wide coordinator or there can be a separate coordinator for each school building. I will say that for districts that choose to have only one contact person as their coordinator for the entire district, they need to be very careful that that coordinator actually understands the safety plan in each particular school building and has sufficient contact with each sufficient school building, because that will be the person that is asked the questions, whether it's from parents or employees. And if we have one central office person who really doesn't know what's going on in an elementary school, for example, that's not going to be an effective plan at all. To the extent that districts can have a separate coordinator for each building, someone that is knowledgeable and able to answer those questions, that is probably the best approach. When it's not possible to have someone in each building, we just want to be very careful that that district-wide person has the information and has the ability to reach out to those particular schools in an efficient and effective way.
Mm-hmm. And I would add that if we have in where there are separate coordinators, that the district also should have established guidelines in relationship to situations that may be like. So for example, we talked about, are we going to have our school nurses let students, send everybody home if they have a symptom, or are we going to evaluate and then decide that we're not going to send people home that either screen positive or have a symptom if it's related to a chronic condition. We would want to make sure that all of our building level coordinators were aware of what the district's policy is in relationship to those situations, so that buildings aren't treating students and staff differently in like situations.
That's true. And if I could just follow up on one point that just occurred to me regarding the previous question about picking students up from school if they have COVID symptoms. So all of our schools, of course, have emergency contacts listed for the students. And we typically think about that if a student has a stomach ache or they have a headache, will mom or dad pick them up? If mom or dad can't do it, maybe a neighbor, maybe a grandparent will do it. In the case of COVID-19, the person who may have been listed as an emergency contact before may not be able to or may not be willing to pick up that student if the parent is not able to. So that's something that perhaps schools should keep in mind, that as far as emergency contacts go, parents should be thinking about, in the unfortunate case that their child develops a COVID symptom, who will be able and at the ready to go ahead and pick up that child, because it may not be the same person that would typically be designated in an emergency contact situation.
We have one new question from one of our private school clients, and that is whether all of this applies to private schools, or is that not yet clear? So I will just answer that question. The Department of Health guidance applies to all private schools, regardless of whether they are state approved, registered, or non-registered. And it is our understanding that the State Ed Department is going to be issuing guidance that is specific to non-public schools. If you're a state approved non-public school, then the State Ed Department guidance applies to you. If you are not a state approved private school, then you may become familiar with the guidance, because it may help you develop your plans and give you a lot of things to be thinking about, but you are not required to follow the educational or instructional requirements that are delineated in the State Ed guidance. So the next question is whether the governor has given any information regarding state aid and how the state aid relates to the 180 days, and whether if you are remote, if you are on a day that your entire district is learning remotely, whether that day will count for the 180 days state aid requirements. Kate, I'll let you take that.
Great. So the Department of Education passed some emergency regulations last week that, in addition to the guidance that Bethany referenced, has also given us some insight into how the 180-day requirement is going to be handled. Simply stated, those regulations provide that for the 2019-2020 school year, during the school closure period ordered by the governor, there was a waiver of the 180-day requirement. For the 2020-2021 school year, which is the school year that we're concerned about upcoming, the regulations provide that if your district is closed due to a state-ordered and state-mandated school closure, so such as an executive order by the governor, then you qualify for a waiver of the 180-day requirement. The guidance then, or the regulation rather, then goes on to say, though, that if you are closed or not providing instruction as a result of your implementation of your plan, implementation of your reopening plan, that you must apply for a waiver from the Commissioner of Education of the instructional hour requirement, which is the 900 or 990 hours that are required. So at this point, we are awaiting further guidance on that point, because whereas the guidance document seems to suggest, and I know Candace was going to get into this as well a little bit, the districts have the option of either going remote, in-person, or hybrid. There does appear to be some aid implications to that. And our best recommendation at this point is that if you are planning on having a plan, a reopening plan that includes a hybrid model where you are in person some days and not in person on other days, that strictly stated the regulations at this time require you to get an approved waiver from the state education department, not from the instructional day requirement, but from the instructional hour requirement. That obviously would not apply if the governor has a state mandated and statewide school closure order. I don't know if Bethany or Candace has anything else to add.
Yeah, that's correct, Kate. So we hope that further guidance on that point will be forthcoming, but you're correct. In the meanwhile, it would be a good idea for schools to seek that waiver if they're going to use a hybrid model, just as kind of a safety net concerning the instructional hour requirement.
Okay, the next question has to do with who can review or should review the screening responses. Can this be done by a non-medical personnel, or does it need to be completed by a school nurse?
I'll take that one. I think that because the answers to the questions should be, we shouldn't be collecting the information that's contained in the answers to the questions. We should only be collecting the information that says, yes, I'm cleared, no, I'm not cleared. You know, I think that if we are that's the information that we're collecting, then anyone could review that. And the guidance says that that the schools should consider and are recommending that there's somebody that reviews all of the screenings to make sure that they've been completed, and that guidance says that it could be an administrative assistant, for example, in parentheses. If we are, you know, if what we would be seeing includes medical information, then we would want to make sure that we're keeping that as confidential as possible and designating someone that would have more confidentiality than a school secretary, for example. But I think that, you know, to the extent that we have programs in place or apps or whatever we're using that allows the individual to answer all the questions that they're supposed to answer, but to not to display those answers to someone else, that would be better. I don't, you know, again, you know, I don't, what the functionality of our apps are at the moment, you know, I can't say, but I think that's, you know, you need to identify what you're collecting and what people are going to be seeing, and then if you're going to have that reviewed as recommended, establish who's going to do that based upon the level of sensitivity of the information that's being collected.
We're going to shift just for a minute to some special education questions that are coming into the chat. So Kate, I'm going to ask you to respond to this question. As the districts have been advised to prioritize students with disabilities, can you talk a little bit about the impact or liability related to LRE requirements? And specifically for this question. It is there an impact if they're bringing in students who are in a co-teach model more frequently than they are bringing in the general education students who would otherwise be in the classroom with those kids?
That's a great question. I think the way that as a group we've really analyzed this question is in thinking that LRE really speaks to the school district's obligation to ensure that special education students are mainstreamed with their typical peers to the maximum extent appropriate for their individual learning needs. To my mind, and this is to some extent uncharted territory, of course, because we haven't seen how these claims play out in a litigated context, but to my mind, school districts would have a very good argument that LRE really has no applicability in a situation where typical peers are not in school as a result of either a state mandated closure with respect to those students or because of the district's obligations to mitigate COVID-19. It's not a situation, for instance, where a classroom of typical peers is being educated down the hallway from those ICT students, and the district is keeping those students away from their typical peers and failing to include them. There are no students physically able to be included with those students, if that's the district's plan. I would say that to mitigate those kinds of concerns that may be raised, to the extent that you can ensure that through digital means or online instruction that typical peers are able to integrate and work with their disabled peers in a synchronous fashion, that would certainly, I think, allay a lot of parent concerns with respect to LRE considerations. I think that that's also potentially, better for the non-disabled students as well, to be able to continue those relationships and contact points with their disabled peers in school. But I think at the end of the day, and I welcome Candace or Bethany to jump in if you disagree with me on this, but I would much rather, especially if I'm your school attorney, I would much rather that you're delivering services in person to those special ed students where feasible, even if that is not in the precise ratio dictated by their IEP and with the precise level of inclusion mandated by their IEP, because the exposure of not providing those services is all but a certainty with respect to the fact that, as Bethany was alluding to earlier, there has been no federal waiver of IDEA requirements, and strict compliance with IEPs is technically required. It will be mitigated to the extent that safety doesn't permit strict compliance, but every time a district is not providing services consistent strictly with a student's IEP, there is an exposure and a risk of a compensatory education claim. So I would rather that you err on the side of providing instruction where safe and where feasible, and disregarding the LRE considerations than not bringing those students back because of LRE considerations.
Yeah, I agree with that, and I would note that there's, the prior guidance, after, one of the secondary guidances that had come out specifically noted that school districts should not be using LRE as an excuse not to provide special education services to students. So I think that that's even with that background out there that the DOE had issued after their first set of guidance came out to say, that we didn't mean for this to suggest that students shouldn't be getting, we should be using this guidance to prevent students with disabilities from getting their services. So I agree that the lesser risk is to provide as much services as we possibly can in a safe and effective environment.
Yeah, absolutely. And one other thing that we were talking about in preparation for this presentation is that the classroom ratios for special education students represent the maximum standard. So in other words, if there would typically be a 12-1-1 class with 12 students, but in this circumstance, you believe that you can only appropriately and safely educate 8 students within that classroom, you would be permitted to do so because the 12 students, that's the outer limit, the maximum, but that doesn't mean that you would not be able to educate less students than that.
So we have a couple questions related to kind of managing kids in the building. And the first question has to do with splitting kids into A and B groups and alternating instruction by the week as opposed to by the day. And the question is whether this would mitigate risk by keeping children in solid groups for an entire week. I will say that the exposure, the kind of the contagion period is up to 14 days. So if you were thinking about doing something like that, I would suggest you consider a 2-week rotation and then really give some thought to the extent to which that's going to adversely impact the students who are home for 2 straight weeks. And I think that the reason that the guidance recommends these cohort groupings of kids is so that kids are not, don't need to be excluded for really long periods of time. And then the other question has to do with movement within the school. And originally we heard that kids should be staying inside classrooms and that teachers should be moving. Candace, are there any updates with respect to that guidance?
Yeah, so certainly the guidance in both the DOH guidance and SED guidance makes it clear that students should be in cohorts as much as possible. So we should be trying to have specified groups of students that kind of stay together, which will of course help in the event that one student becomes ill, because then we have a smaller population to deal with in terms of contact tracing. The teachers moving in and out of that classroom, we know that one teacher can teach more than one cohort. So you can have cohort A and cohort B and one teacher that moves between those 2 cohorts. The guidance does state that the teachers should be practicing social distancing with both cohorts. So that is a possibility. And I don't think that there's any prohibition in the guidance regarding teachers kind of moving in and out of those 2 different classrooms. In fact, it anticipates that situation by saying that if that needs to happen, just practice social distancing when dealing with those 2 different groups.
I would add that a lot of these, these student, trying to keep students in cohorts and how you reduce concentration of students, which is really what we're talking about with A and B groups and cohorts and contact tracing requirements. Each school district have to balance the need to be able to provide the instruction that they want to provide and their capacity to provide alternative instruction during times when it's not in person, with the safety issues. So, and with practicality. So, Kirsten mentioned that the incubation time for COVID exposure is 14 days. So that if you if it's every week, then you're not technically secluding students for the whole time. So you would have to make sure that you had your disinfecting and procedures and cleaning procedures in between each of those weeks, if that's how you were going to address it. So the question there would become, is it really saving us administrative time or other time to do that model? But I think that we looking at the guidance, cohorts are definitely something that I would recommend, we would recommend because it's recommended, but also it seems to be one of the more easily affected accommodation during this period of time. And it makes things down the line a little bit easier with regards to student movement through schools, and how you do the scheduling to reduce concentration of students to help with social distancing. Those are things that are going to be school by school specific based upon what your capacity is and your space needs are, and how you might be able to use your space. And it's in our canned questions, but we probably won't get to them because you've got so many questions. But one of the things to remember is that if you're going to be using space differently than is expected, like if you're going to use a gymnasium as a classroom so that you can spread kids out, or a cafeteria as a classroom, or other spaces, in ways to increase your ability to social distance or increase your capacity, but they're different than you would expect from the original design. The guidance requires that you seek Office of Facilities Planning approval for those types of changes that you might be making. So you need to think about those and get that approval, before school starts.
That's right. And I'll just chime in with one more point to piggyback what Bethany said. When you're submitting those requests for approval to the Office of Facilities Planning, you want to be sure to include that it's a COVID situation right on the cover page so that they will expedite those requests. Otherwise, it may end up in a pile of things that can wait for another day. So just be sure to mention that it's a COVID-related change on the cover page of your request.
So we have a couple questions about teachers, and before we shift to the employment questions, I'm going to ask there's a couple questions similarly related to the student management in the building. And that is generally, if students refuse to wear their masks or if they refuse to socially distance, are they subject to district's codes of conduct? Are they subject to discipline? And, what other kind of options do districts have to deal with kiddos who are unwilling to comply with the requirements?
So I can get started on that. I mean, I think that what is reflected in multiple places in the State Education Department guidance is a reiteration of the department's preference for restorative practices for addressing student discipline and behavior concerns. It's cited in the context of the material on dealing with social emotional learning. It's also cited in other aspects throughout the guidance. So I think the department seems to, and this is not new, this is something we've seen for the last few years, but the department is certainly expressing a strong preference for restorative practices in lieu of punitive discipline in terms of addressing student misbehavior. That said, there's nothing about this guidance or anything in the emergency regulations that we saw or any of the executive orders that would deprive a district of its right to implement and apply its code of conduct. A student who is refusing to wear a mask at the very least would likely be guilty of violating one or more of a district's codes prohibiting disruption of the public space, disrupting school environment, failing to abide by a reasonable directive of a building administrator, etc. It would likely be sufficient to constitute a violation of the district's code of conduct. Of course, for students with disabilities, if there's a disability-based reason for that defiance or misbehavior, certainly you would have to comply with the IDEA and the due process protections under IDEA for manifestation determinations. I will also note that there's a little known and little utilized provision in 3214 of the Ed Law, which is our student discipline provision, that also allows the school superintendent to change a student's placement where it's necessary for the good of that student. And I would argue that that's a section that we may see having greater applicability as we enter this school year, that a superintendent may make the determination that a student needs to be, for instance, on distance learning or doing remote instruction as an alternative to in-person instruction, if it's in that child's best interest because they cannot abide by health and safety provisions that in the district's reopening plan and according to state ed and DOH guidance. So I would encourage you to look at those options and explore those possibilities as well. They're a little less punitive. It's not about did the district or did the child rather disobey a provision of the code of conduct, but more about what is necessary to keep everybody safe. And certainly there's options under IDEA for dealing with students who pose a safety risk as well, that we can help you explore if that comes up.
Thanks, Kate. Anyone else have anything to add to that? So the next group of questions has to do with documentation related to employees. And so the first question is, are staff and faculty required to provide medical documentation for situations where they believe they are at risk to be in school due to a health condition. So they have asthma, for example, and they want to request an accommodation. And we can talk a little bit about what they would do.
So under reasonable accommodation analysis under the human rights law or under the Americans with Disabilities Act, a staff member who is requesting an accommodation, you are entitled to secure medical documentation to support that accommodation request. You don't have to. It's good practice and best practice to have a policy that you will secure that documentation and ensure that those requests are supported, because that way you're not picking and choosing from with different people on who submits a document and who doesn't. It may be possible that you already have documentation related to an employee's request to work remotely, for example. They may have taken leave. They've already submitted an FMLA request for intermittent leave because they have diabetes, for example, or because they have asthma. They've already submitted a leave request or some other kind of accommodation request because they're seeking treatment for cancer or some other underlying condition. If that's the case, then certainly you wouldn't need to have additional documentation, but you may require documentation of a medical condition to support an accommodation request, which is really what this would be.
I'll just add to that we had spent some time talking about the use of the term accommodations throughout the guidance documents. Particularly, you'll see in the Department of Health guidance that they speak to accommodations for people who may not feel comfortable in the building. And we will just note that does not and should not be viewed as being synonymous with reasonable accommodations required under the ADA and the ADA analysis.
Mm-hmm.
So the next question related to an employee is if the employee has tested positive for COVID, but the Department of Health determines that they are not going to do contact tracing for those that employee came into contact with, what is the district's responsibility, and perhaps what barriers should the district be mindful of as it thinks about whether it needs to reach out to employees or students?
The guidance, you may have already come across this, and if that's the case, then forgive my naiveness, but it's hard to imagine that if somebody was tested COVID positive, that the Department of Health would not do contact tracing, because they're required to do that. But to the extent the guidance requires us to cooperate with the Department of Health. And so I think, my first response to that is I would contact your school attorney, because that's fraught with issues in the sense that you potentially would be revealing medical information, confidential medical information about an employee or a student. And you would want to be very, very careful on how you address that. What I would say is that there's nothing in the guidance that would require a school to be the one to notify individuals in relationship to contact tracing. The guidance requires that we notify the Department of Health and that we work with the Department of Health to assist them with their contact tracing. But if you feel, that there's, a risk involved to your students and to your staff because the Department of Health isn't fulfilling that obligation, then that's the time to call your school attorney.
There's a question that I think was in a news article that kind of circulated throughout the state yesterday or today regarding districts' kind of liability. So can you talk, somebody, maybe Candace, talk a little bit about how concerned districts should be about making their decisions based on the risks related to liability, and Andrew asks, given the flexibility that districts have in the guidance to use these three possible models, how should they look to make calls on risks given those liability concerns?
Right, so I believe the article that you're referencing is one that came out, like you said, either today or yesterday, talking about the fact that certain organizations, I believe it was perhaps the New York State Association of School Superintendents, I believe that was one of them, was looking for some type of liability waiver or some statutory mechanism so that school districts would be held harmless if someone tried to make a claim against them for contracting COVID-19. And it's not new in the sense that many business owners throughout New York State have been looking for something similar over the past few months. So in other words, if a customer comes into their store and gets COVID-19, they didn't want to be sued for that, and they were looking for some type of waiver or exemption so that they would not be subject to liability in that circumstance. I don't know how successful that will be, and as Kate was pointing out before with liability waivers, it's going to be very difficult to have that enforceable, certainly if it's signed by a parent, and I don't know of any waiver that would exempt a school or a business or anyone else from that matter, from negligence. So regardless of what develops in terms of a law or statute, I don't think that it's going to just be a blanket, okay, everyone has a free pass, and if anyone gets COVID-19, you can't be sued, because in the event that someone is outright negligent in putting safety precautions in place, I don't think that that will protect them. I don't know if that kind of answers the question, but we're not recommending liability waivers at this point. I guess the primary takeaway is to try to be as safe as possible and to comply with the DOH and SED guidelines as much as possible to make sure that you're not subject to one of those types of negligence claims, and to make sure your insurance policy is as strong as possible.
And the only thing, the last point was what I was going to hammer again, that whenever we get questions about liability, there's the little L liability, which is somebody going to assert a claim against you, and kind of the big L liability, which is kind of court ultimately hold that you're financially liable to another person for the district's negligence. And the best protection against both of those types of claims is robust insurance. As one of, school districts and other schools in the state are some of the most complex organizations in the state, and you incur liability literally every day you do anything in operating your organization. There's always a chance somebody can slip and fall, somebody can get sick, somebody can, that you employ can hurt somebody else, for instance. And usually our advice with respect to those issues is, as Candace said, you follow the best guidance to the best of your ability of your state regulators, in this case, the DOH and the NYSED, but you also ensure that you have insurance so that where the district is not negligent, but nonetheless faces claims, you have the ability to pay those claims without having to dig into your fund balance. The only other thing I will add also is that I think there's also a tendency to think about liability as being one-sided in these situations. Of course, there is the personal liability considerations. I believe in the article that Candace was referencing, Jay Warona from the School Boards Association was cited as saying, the districts I work with are more concerned about children getting sick and children being injured and the safety of children than they are about liability. And I can personally say, with respect to the districts I work with, and I think each and every one of us on this panel, that is absolutely the case. I thought that was a really great point that Jay Warona made as well. In addition to avoiding liability, I'm sure each and every one of you on this call, first and foremost, just wants to make sure that your kids are safe. And the best way to be doing that, of course, is to comply with the best guidance you have. But I will say that there's liability on both sides. So we've identified one of those forms of liability on this call, for instance, the liability to special education students if you're not delivering services in person. There's the liability to ELL students who may be impaired as a result of the not receiving services in person. and just the liability to all vulnerable populations, as Kirsten alluded to earlier, in terms of students who may, fall through the cracks as a result of not getting instruction. So there's liabilities on both sides that certainly need to be balanced. And I think the good thing about the state guidance, and I don't say that very frequently, but the good thing about the state guidance is that it does create tremendous local flexibility around how to craft a plan that your organization can comply with to make sure that you are minimizing liabilities, but also maintaining safety.
So we have time for just one more question. A question from regarding the charters, and the question is it confirmed that the charter schools can open entirely remotely in September and that they can do a phased-in approach for in-person? The answer to that question is yes, that both the State Ed Department and SUNY authorizers have indicated that that is an acceptable plan, but it does not in any way absolve the charters from following all of the instructions in putting together a plan. And if you are a SUNY authorized school, you should know that there is a guidance document specifically for SUNY authorized schools that probably supplements what's required to be submitted in your plan. And then the last question, and I'm not sure whether Bethany, Kate, or Candace, you'll know this right off the top of your head. There's some circumstances that talk about 14 days and others that talk about 10 days. Do you have a quick and easy rule of thumb on the distinction between what applies to 10-day requirements and what are the things that apply to 14 days?
Sure, it sort of just depends on which you're responding to. I think one would be, so if you are, if you travel to a place that's a hotspot, if you are in contact with somebody that's COVID positive, the guidance in relationship to self-quarantine or mandatory quarantine will be 14 days. The 10-day requirement or 10-day number is part of the DOH and NYSED guidance in relationship to when someone might be able to come back to school or to work after exhibiting COVID symptoms or screening for COVID. And so it's 10 days after the symptoms begin, which presumes a period of time that somebody was exposed before their symptoms started. That's why it's different. Or 3 days after symptoms end or become or reduce. So those are the two. That's why some say 10 days and some say 14 days. The 14 days is the incubation period in relationship and the mandatory quarantine period. And that 10 days comes from the guidance in relationship to when individuals might be able to come back to work or come back into the building. And that, and all I can say about that is that that's sort of just the difference in when you're talking about the person who's tested positive.
Thanks, Bethany. So we are out of time, and we're sorry we ran over a couple extra minutes. We hope that we were able to respond to most of your questions. And certainly this PowerPoint presentation will be posted on our website, and the webinar has been recorded. So please feel free to contact our firm if you have any additional questions or you are having any difficulty accessing the materials from today. With that, I will turn it over to Kathy to end our webinar. Thanks, everyone.
Thank you.
Thanks.
Thank you.
All right, thanks everybody for attending. We wish you a wonderful day, and please take a moment to complete the survey. Take care.